One day in 1987, there was a criminal case that left several policemen seriously injured, and the crime had a severe impact on all the nearby residents involved.
And also again in 1993, an accident involving the first defendant caused him minor injuries and also triggered a state of post-traumatic stress disorder, which initially manifested after the 1987 incident, and he was unable to continue the police force.
The trial judge took into account the possibility that plaintiff's post-traumatic stress disorder may have been triggered by some future torturous incidents during his police service and reduced the amount of damages. Lord Rick argued that compensation was not physical injury, but for the loss he suffered as a result of that injury.
The loss was not due to stiff leg but was the inability of the claimant to live a full life and enjoy the facility he used to enjoy and earn the money used to earn it. The second injury does not reduce any of it, so why should it be considered to have eliminated or replaced it? In other words, the loss of the claimant after the removal of the leg should be considered to have had two simultaneous causes.
There was a case called Walker versus Northumberland County Council having the same issue. The fact Mr. Walker was a social worker employed by the defendant who had a heavy and emotionally demanding case load and suffered a mental disorder in 1986. He was fired, being unwell, and brought action against the defendants for violating their duty of care to be taken measures to ensure he has a manageable workload.
The decision: there is no logical reason to exclude the risk of psychiatric injury from an employer's duty of care. Since the first breakdown was not reasonably predictable, defendant did not violate for failing to take steps to avoid it. A second breakdown, however, is predictable if Mr. Walker is not offered additional support.
The fact Mr. Becker was a pedestrian who was struck by defendant driving a car in September 1964. The negligent driving by the defendant caused serious injuries to his left leg, causing him to have mobility problems and to be unable to work in the labor market as he had done before. This causes income to decrease. In November 1967, and prior to trial, Mr. Becker was the victim of an innocent armed robbery at his workplace and suffered multiple gunshot wounds in the leg. This is the same leg that was affected by a car accident, and it was then amputated.
Defendant is held liable for loss and reduction in income. The court took that view that if Mr. Willoughby had not been negligent in his driving at first, the complainant would not have lost his leg. Therefore, he is still responsible as if the shooting never happened and must pay compensation for Mr. Becker for the loss after the car.
It has been stated that when there are two consecutive accidents and contribute to the same injury, the original defendant will be liable for the overall injury.
That's all from
us.
us.